Ladies and gentlemen, thank you for joining us today and welcome to the first Investing in India program. My name is Nidhi Kilawala and I am a partner in the firm's corporate practice group. I would like to extend a very warm welcome to every one of you, wherever you are around the world. Next slide, please. Foreign investors into India often have difficulties because of differences in culture, law, and business practices from those in their home countries. Investing in India is a program designed to provide information and insight into some of the difficult and complex issues often faced by foreign corporate executives, in-house legal teams, investment banks, other intermediaries who are interested in investing in India today, as well as their advisors. This program will provide regular information on diverse legal areas relevant to every investor. For example, we will deal with employment, intellectual property, and with real estate aspects of investing in India. The objective of the program is to improve understanding and appreciation of the issues often faced by foreign investors and to assist in finding solutions to some common problems, or at least offer some different approaches which could prove to be some food for thought. The program seeks to assist both existing and prospective investors in India. Not all elements of the program will appeal to every potential audience member. Some elements may focus on specific sectors like venture capital, private equity, and technology, whilst others will be more generic. Given today is the pilot program in this particular series, today's session will be a more generic one, in that it provides an introduction to the legal framework which is essential to any understanding of doing business in India. We apologize to existing foreign investors who may already be aware of some of the content, but please stay with us because you are likely to learn some new things. On this slide is the agenda for today's webinar. If you do have questions, please submit them using the facility provided in the webinar portal. If we do not cover questions during the webinar, we will respond offline by email after the webinar. Also, please note that a copy of the presentation, the summary notes, and a recording of this webinar will be sent to you after the webinar as a matter of course. Next slide, please. India has sustained its momentum as one of the fastest growing economies in the world for nearly a quarter of a century since the liberalization of India in the early 90s. In recent times, favorable geopolitical forces have influenced significant and sustained levels of foreign investment into India at unprecedented levels. Earlier this year, Mr. Modi was elected for a historic third term. He is already India's longest serving Prime Minister. Since 2014, India has enjoyed a stable domestic government under Mr. Modi. His government is very much pro-foreign investment, and this can be seen through a number of very important legislative reforms that have been introduced, which are aimed at making India a more attractive environment for foreign investors. Some of these include relaxation of Indian exchange control laws, where the foreign direct investment policy has been relaxed, and further clarity and relaxation has been provided for investment in sectors such as space, insurance, telecom, etc. The Reserve Bank of India has also simplified various regimes such as the regime around share swap transactions, which further facilitates deal making in India and encourages alternate mechanisms through which foreign investors can invest in Indian companies. Corporate reforms have also been introduced where companies that are incorporated outside India with Indian subsidiaries in their structure are now permitted to flip back to India through a simpler mechanism. Taxation reforms such as the introduction of the GST, which was aimed at simplifying taxation, promoting ease of doing business, and creating a common national market, has truly been hailed as a transformative legislative change by both business owners and investors alike in India. The abolition of the angel tax has also boosted further foreign investment into India. India is therefore already looking like a very attractive destination for foreign investors. Not only do we have a growing middle class of consumers and a vibrant corporate sector, but we also have an emerging companies and startup ecosystem, which is currently the envy of the world. It has literally exploded into over 100 unicorns in the last 4 years, and this is fueled by massive private equity and venture capital investment. India is well on its way to becoming the third largest economy in the world in the next 3 to 5 years and will be the largest country in the world within the next 10 years. With more than 25% of the world's population under 30 years of age in India, India's demography positions it extremely well for the future. It's therefore no surprise that India is an investment theme for many global investors. Several investors who are seeking growth are also interested in what India has to offer. These are some of the reasons why India is an attractive investment target and the very reason for why we thought to put together this program and bring it to you. Let me now introduce you to our speaker for today. Everyone who has registered for this webinar should have received by email already a resume of both our speaker and me. So there is no need to spend much time on introductions. Suffice to say that Mr. Prasenjit Chakravarti is a very experienced corporate partner in our firm who has had extensive experience dealing with foreign investors investing into India. So I would now like to invite Prasenjit to make his presentation. Over to you, Prasenjit, and thank you so much for being here with us here today.
Uh, Thank you, Neri, for the very kind introduction and greetings to everyone around the world who have tuned into this webinar. I hope you will find this webinar very informative. Can we go to the next slide, please? First, let me give you an overview of what we will cover in today's session. The presentation is structured to provide a broad understanding of the legal framework for investing in India, broken into four broad sections. Firstly, we will examine the government and legal structure. And this is very critical to understand because it's fundamental for a foreign investor to know how laws are created, enforced, and applied across different states and sectors. Uh, and this will give you the much needed clarity, including the division of powers between central and state governments, etc. Next, we will focus on the key regulators because they are the ones who will oversee foreign investments, focusing on their role, compliance, and approvals, etc. Uh, the third is the key laws, where we will focus on specifically foreign exchange law and corporate laws, but also give a broad overview of other relevant laws important for a foreign investor. And of course, we will then do a quick roundup through a conclusion and takeaways, and then take some questions, which will hopefully leave you with some actionable insights for your investment strategy in India. So let's dive into it. I think we can go to the next slide, please. Yeah, so let's start off with government and legal structure. If you go to the next slide. Yeah, so firstly, India is a federal system, and the way it is structured is the powers are distributed between center and states. Uh, Today, we have 28 states and 8 union territories governed by a strong central government. The central government holds overarching powers, ensuring uniformity in critical matters. The powers are divided as per the Constitution of India, uh, with three lists being there. The Union list spells out matters on which the central government has jurisdiction, the likes of defense, foreign affairs. Then you have state lists where the state has exclusive domain, like police and public health. And then you have concurrent list items, which are shared subjects basically between center and states, the likes of stamp duty, education, environment, etc. In case of a conflict, it's the central government which will prevail. Insofar as any items like digital assets which are not actually spelled out in any of the three lists, central government will have the final say on these matters. Uh, This is very important because, let's say a foreign investor wants to acquire, a land for operating his factory in a particular state. Now, the stamp duty may well vary from one state to other, and therefore it's critical to know the differing rates which are applicable in this. Next slide, please. So now we spend a few minutes on the Indian Constitution. The Indian Constitution is really, if you ask me, the backbone of India's governance and legal framework, providing stability and predictability for investors. Some of the key aspects and salient features would be that, well, firstly, after gaining independence, India adopted this constitution in 1950, and it is one of the most comprehensive constitutions in the world with nearly 400 articles addressing governance, rights, responsibilities, etc. Uh, and it also reflects the aspiration of a new independent India with several global governance principles to kind of suit its unique needs. Uh, One interesting historical fact is that there was a drafting committee which was constituted to draft a constitution, and one of the prominent drafting members of that constitution committee was Mr. Devi Prasad Khetan, who also happened to be one of the founding members of Khetan and Company. This really highlights the connection between India's legal heritage and its modern day governance systems. Uh, in Now, the kind of parliamentary system we have followed is really modeled on the British system, where president happens to be the ceremonial head and prime minister wields really the real power, leading the executive branch, uh, derived from the majority party in parliament. This is important because this gives transparency in policy making and accountability of the executive to the legislature. A quick example would be the GST, the Transformative Goods and Services Tax, which was debated extensively in the parliament before it being introduced for the businessmen, etc. The other key point is, the principle of separation of power, which really means that the powers between the legislature, the lawmaking body, the executive who implements the law, and the judiciary who interprets the law are basically separate, and you can't really encroach into each other's domain. Uh, the equally Another critical power is the power of judicial review. Now, why is that critical? Because in case there is a law which has been promulgated by the parliament which is unconstitutional, the Supreme Court has in the past struck down such laws as unconstitutional. Equally, if there is arbitrary executive action which has been taken, that also has been uh, ruled down by the Supreme Court, and Supreme Court has come to the rescue of investors and businessmen in those kind of cases. Now, this is very critical overall, as I said, because uh, any investor would want fairness in a country's system, and I think overall this architecture gives them a lot of confidence to investors who want to do business in India with the predictability and reliability of the jurisdiction enshrined from the Indian Constitution. Next slide, please. Uh, Now let's spend a few minutes on the central government. Now the central government plays a pivotal role in shaping India's policy and regulatory environment, which directly impacts foreign investment. And now, to examine the structure, India follows a bicameral parliamentary system. There is, of course, the Lok Sabha, the People's House, where members are directly elected by the public. This house is responsible for passing laws and approving budgets. For instance, fundamental laws like the GST, the insolvency bill, and insolvency laws were passed by Lok Sabha, ensuring a broad representation of public and business interest. Then there is the Rajya Sabha, the lower house, the upper house rather, the Council of States. Now, here the member represents the states and union territories, acting as a reviewing chamber for legislation. So any key legislation which is, let's say, first mooted in Lok Sabha has to be approved by the Rajya Sabha by the requisite majority. And again, bills like insolvency and bankruptcy code underwent extensive review and debate in Rajya Sabha, and which highlights the balance between regional and national priorities. Uh, Spending few minutes on the central government, the current Prime Minister, Mr. Narendra Modi, who leads the Bharatiya Janata Party, has returned to power for a third consecutive term in 2024. This has obviously provided continued political stability, fostering investor confidence, and enabling bold economic reforms like the production linked incentive schemes. An interesting fact is that this time around, this is a coalition government, and therefore the coalition alliance is known as the National Democratic Alliance. While BJP continues to lead the coalition government, but given its reliance on few key allies, one may reasonably assume that some aspects of reforms may witness a bit of slowdown because there may be an element of consensus building which may be required, and that may take time. For example, areas like tax rationalization or introduction of land reform laws may need more time than ordinary it would have. But having said that, the government continues to be an extremely reform oriented government, and it will surely kind of navigate those challenges as it moves along. Next slide, please. To conclude this section, well, the judicial system is so critical, I would say, because if the judicial system really is at its best, it enforces rule of law, fairness, and predictability, which are critical elements for any foreign investor to derive confidence. The structure is that at the top of the kind of chain is Supreme Court, which is India's apex judicial authority, and its decision is binding on all courts. So it's the kind of highest jurisdiction in terms of any matters, in terms of civil matters, criminal matters, constitutional matters, or appellate matters. Whatever it decides, it will be final and binding on all other courts, including higher courts. Next to the chain is high courts. Now, each high court will have its own kind of state will have its own high court. Today we have 25 high courts, and these high courts decisions are also binding on the subordinated courts, and that's also very very important, so that there is clarity if a high court X has decided on a particular question of fact and law, then a district court or should be bound by that judgment. Then comes the district courts and tribunals. The district courts really deals with low value civil matters, criminal matters, and they also help in attacking, kind of the low value matters. There are specialist tribunals. Now, these are very important to ease the burden on the courts, for the simple reason that because there are so many cases which are pending at various courts, and these tribunals like the National Company Law Tribunal, which handles corporate disputes, mergers, insolvency, has come as a great boon. Equally, you have got the Income Tax Appellate Tribunal, which deals with income tax matters. These are constituted or specialized professionals who have the background and intellectual capacity to deal with this as well. Uh, the other, I think, I would say, key point here is that uh, there is the concept of stare decisis, which means really every decision of a higher court has to be followed by the lower court. But what this really tells you is that there is predictability because there are kind of clear hierarchy defined, jurisdiction defined. There's fairness. There is efficiency because of tribunals, and in many cases, we have seen that courts have intervened and helped out business people and foreign investors. I cannot think of a better example than the pandemic, when the force majeure clauses were interpreted in a very pragmatic way and not in a theoretical way. And the courts really did bail out and come to rescue of many a foreign investor and clients of ours in absolutely unprecedented crises like COVID. Uh, we can go to the next slide, please. Now, I think it's time to talk about the key regulators, because when you invest in India, it is essential to understand the role of various regulatory bodies that oversee and govern business activities. The regulators are the ones who ensure compliance, transparency, and stability in the Indian market. Uh, Next slide, please. So on this screen, as you can see, there are six regulators we have spelled out. Of course, there are more regulators, but these are the fundamentally important ones when you, as a foreign investor, invest into India. The first one is DPIIT, the Department of Promotion for Industry and Internal Trade. Now, DPIIT is responsible for framing India's foreign direct investment policy and approving proposals which need foreign government approval. It acts as a facilitator for industrial growth and investment promotion. For instance, if a foreign investor is looking into defense sector and wants to acquire 100%, now that's really not allowed because you can only acquire up to 74%. And therefore, all the dialogue and form filings to seek that approval will have to be done with DPIIT in consultation with the relevant sectoral expert and the sector. Uh, then the Reserve Bank of India. Now that's really the central bank of India. This regulates the foreign exchange transactions under Foreign Exchange Management Act. It oversees all kind of foreign exchange dealings like repatriation of profits from India to offshore, capital inflows, foreign loans. So, for example, if a foreign investor wants to remit funds into India, it will have to comply with the pricing guidelines laid out under the Foreign Exchange Management Act. Next is the Securities and Exchange Board of India. Now, the Securities and Exchange, Board of India regulates and the securities market and protects investor interest. So it oversees stock exchanges, mutual funds, foreign portfolio investments. So any investment by a foreign institutional investor will have to be in conformity with the SEBI laws. And also anything to do with insider trading or takeover regulations, all of these is administered and governed by SEBI. Ministry of Corporate Affairs is a critical body because this uh, regulates corporate governance and enforces the Companies Act 2013. Uh, this will ensure compliance with company laws, including incorporation, mergers, winding up, etc., etc. Uh, for instance, when a foreign investor wants to set up a company in India, it will have to make requisite filings which are required in the company law, and it's the Ministry of Corporate Affairs which will really govern that. Competition Commission of India is another key authority because it enforces and prevents anti-competitive practices and ensures a fair marketplace. It reviews mergers and acquisitions to avoid creating monopolies or reducing market competition. Uh, the next key authority is a Central Board of Direct Taxes. Now, this administers income tax laws and oversees tax compliances for business and individuals. It plays a significant role in matters like corporate taxation and transfer pricing, amongst other things. For instance, if a foreign company is earning profits in India, it must adhere to tax filing requirements under income tax law, which is overseen by CBDT. Then we come to data privacy board, which is another important, sectoral, I would say, board. And there are several sectoral boards like which can play a role. For instance, you will have insurance regulatory authority when you invest in the insurance space. There will be defense authority when you invest in defense space. There's pharma authority when you invest in pharma space. Data privacy authorities will tackle data privacy laws, and therefore you must also abide by the sectoral laws along with these authorities when you deal with them. Uh, let's move to the next slide, please. Now, I think having dealt with the key regulators, it's imperative that we talk about the key laws, really, and which really forms the legal framework for investing and operating in India. These laws, cover various areas ranging from corporate governance, sector-specific regulations. What I will do is provide you a brief overview and practical insight of the relevant laws at a high level, and then zero in on corporate laws and foreign exchange laws. Next slide, please. So I think the first law here on the screen, as you can see, is foreign exchange laws. Now, uh, this is obviously very critical, uh, and the reason being that any investments which are made by a foreigner will have to comply with foreign exchange laws, and that's really the sum and substance of any foreign investment. The principal legislation will be the Foreign Exchange Management Act of 1999. This will regulate foreign investment, fund repatriation, cross-border transactions. Uh, and a foreign investor acquiring shares must report, for example, its transactions to the Reserve Bank of India through the authorized dealer banks. Now, what is very interesting is that this is something which has been liberalized significantly over the years, and the foreign exchange laws have become far more liberal. I think the next key point is the corporate laws. The corporate laws, the cornerstone of corporate law is Companies Act 2013. Now, just to take a step back to the historical evolution, the Indian company law was first introduced post independence in 1956, which overhauled the pre independence law of 1913. And these are again largely based on the UK Companies Act. And of course, today we have the 2013 Companies Act. Why this is an important fact to note is that Indian legislators have adopted and modeled this company law with necessary tweakings based on well-known and settled company law of UK. And therefore, that gives a lot of stability, predictability to the Companies Act, and investors from around the globe can take a cue as to what could be the rationale for some of the legislative provisions which are there. Uh, the other laws which are relevant are bankruptcy law. I think bankruptcy laws are obviously very important, and the Insolvency and Bankruptcy Code provides for time-bound resolution, a framework for distressed businesses. That this has been a game changer in many ways because foreign investors now have the a confidence that they can recover their dues efficiently. So that's a very important law. Environmental laws, well, India has a bunch of environmental laws like the Air Act, Water Act, etc. Uh, and with the more and more focus on ESG, environmental law is assuming a lot of significance. Uh, of course, there is competition law also, which is there, and India has a very robust Competition Act 2002, which prevents anti-competitive arrangements, abuse of dominant position, irregular mergers, etc. And the CCI, kind of reviews the transaction so that there is no harm to the market and the competition. Uh, and then next is taxation. India has Income Tax Act 1961, which really governs the corporate and personal taxation, and the indirect taxation is governed by the transformative goods and services tax law. And for data and IT, now that's another very important law. We have the Information Technology Act of 2000 and the recently introduced Digital Personal Data Protection Act 2023, which governs data privacy, cybersecurity, and IT operations. So any foreign company which deals with customer data it has to be extremely, extremely vigilant and mindful of these laws. And of course, as I mentioned, there are sector-specific laws like sector-specific regulators, and whether it's kind of insurance law, defense law, real estate laws, depending on the sector you plan to invest in, you must be kind of compliant with those. Now let's dive into the corporate law. If you go to the next slide, please. Thank you. So I think firstly, as I mentioned, that company law 2013 is the really the critical law, and that has evolved over the years and modeled on British law, and therefore a lot of confidence has been given. Specifically, well-known concepts like corporate wheel and independent existence of a company separate from its shareholders, limited liability of shareholders, doctrine of ultra vires, all of this have been well known universally accepted principles, and you will find them in Indian company law as well. So that's the first critical point to note. In terms of corporate entity options, I think if a foreign company is looking to establish Indian company to do business and wants to set up a wholly owned subsidiary, it can do that. If it needs a joint venture partner for leveraging local expertise, or because of a, let's say, regulatory requirement, say you can only have up to 74% stake in defense, you need a joint venture partner. So for that, you will need a joint venture partner. And if you wish to explore the market, Indian market, test the waters, then perhaps a branch office or a liaison office would be more suitable. So really, it kind of depends on what's the objective that will dictate the kind of structure a foreign investor adopts. Also, depending on your structure, the taxation will have its own bearing, and therefore one has to be extremely mindful of the tax and operational flexibility angle as well. Uh, the next point is on the minimum number of stakeholders. Now, if you, as a foreign investor, set up a private limited company, you just need two shareholders, and that's good enough. Uh, and if you want to set up a public company, you need a minimum of seven shareholders. So naturally, the compliance burden goes up. It becomes a bit more complex. And if you wish to set up a limited liability partnership, which is often is resorted by service companies, not really manufacturing companies, then you need two partners. Uh, but I should clarify that it's a private company, which is the most commonly resorted structure in India, and that's easier to set up, easier to manage, and the compliance cost is significantly lower. When you set it up. In terms of stakeholder meetings, well, Companies Act does regulate shareholder meetings. So, for example, when it comes to board meetings, there should be at least four meetings in a year with a gap no more than 120 days between two meetings. Annual general meeting of shareholders, every company needs to have one where you have to present your financials and then approve them through your shareholders. These are all very important because the more meetings you have in a structured way, it gives clarity to investors and a proper structured way. Uh, if you go to the next slide, please. Now, insofar as the power and governance is concerned, it's very important because there are responsibilities, power, duties. All of these are interested on, for example, directors who have a fiduciary duty under Companies Act, so they cannot act whimsically or, let's say, in a partisan way in favor of an investor or the shareholder who nominates him or her. They have to discharge a fiduciary duty role. Equally, there are regulators who have powers like the Ministry of Corporate Affairs, who can clamp down and exercise powers to prevent any kind of, let's say, violation of company law. uh, Even National Company Law Tribunal can step in and protect minority interest, as there are provisions of oppression and mismanagement spelled out under the Indian company law, and that can come to the rescue of minority shareholders. Uh, Now, this is very important for obviously any foreign investor, because if you have a fair and transparent system where you cannot be really kind of be bullied by a majority shareholder, all of these can give you a lot of confidence. And if the governance systems are clearly spelled out on the company law and is enforced effectively, that also gives a real boost of confidence. In terms of the structure of board of directors, a private limited company must have at least two directors, and one of them must be an Indian resident. Now, at times it becomes challenging for foreign investors if they only have two directors and one of them, let's say, is its employee who is an Indian resident. Then there's a deadlock of sorts intrinsically because there is one foreign director, one Indian director, and therefore you must, in that case, be innovative by having, let's say, a three-member board, and you basically have a majority of 2:1. A public company must have three directors, and if it exceeds certain thresholds in terms of paid up capital, you must have independent directors and even a women director. Uh, in terms of the role of various directors, there is the independent directors, if required to be appointed, they discharge again a completely impartial role. And that's also bring a lot of credibility as well as professional expertise. And a well-structured board is always, good for balanced operational and governance needs to be met effectively. Uh, the board meetings have to be periodically held, as I mentioned, 4 meetings in a year with no gap more than 120 days between each meeting. And of course, any board meeting has to comply with a lot of secretarial standards, like how the agenda should be drafted, how well fleshed out should it be, and so that a well informed decision can be taken. And of course, if any of this is not done properly, the enforcement, as I mentioned, is extremely strict, and a lot of companies have received the rap on their knuckles because of slipshod compliance with company law. Uh, so I think we can go to the next slide, please, on the foreign exchange laws now. Excellent. So I think foreign exchange laws, as I mentioned during the introduction, is a crucial aspect of India's regulatory framework, and because they will govern the foreign investment and operations within the uh, country. Now, uh, as a broad comment, I think most sectors in India today fall under automatic route, which means you don't need any government approval before investment. For example, any manufacturing space or any service sector, don't need a prior government approval. Obviously, there are certain sensitive sectors and strategically important sectors like defense, where the investment is regulated. For instance, the defense sector, which allows 74% for an investment at the automatic route, and investment beyond that needs government approval. Uh, Equally, for insurance, up to 74% you can acquire on the automatic route, and then you need government approval beyond that. There are certain sectors which are completely beyond bounds, and these are really gambling and betting, lottery, atomic energy, these kind of sectors which you cannot invest kind of anything as a foreign investor. So that's the other key point to note. The principal legislation, which lays out all this is Foreign Exchange Management Act with the Foreign Direct Investment Policy, uh, and one critical law which I must make a mention here is the Press Note 3 of 2020. Now, this was introduced in 2020, right in the midst of COVID, which basically says that any country which has a land border with India, if that country is investing directly or indirectly into India, prior government approval is needed. So, for example, a US company which is controlled by a Chinese or Hong Kong entity is acquiring shares of Indian company, it will need prior government approval because there is an indirect control of the Indian entity pursuant to the transaction by the Chinese entity or Hong Kong entity. Now, this is important because this approval is not easy to come through and takes 7 to 8 months, and can be a stumbling block in the transaction. Uh, Another key facet of Foreign Exchange Management Act is it deals with issues like repatriation of profits, transfer pricing, reporting obligations. All of these, will be broadly dealt with by the FEMA, and you will get a very good sense when we, deal with this investment and repatriation type of issues. Next slide, please. So I think the first here the next point is the entities in which kind of you can invest and who can invest. I think as a foreigner, I think you can uh, set up wholly owned subsidiaries, joint ventures, branch office, as I mentioned that, and you can directly invest as a foreign investor or as a foreign portfolio investor in venture capital funds. Uh, and the second important point is when you invest as a foreign investor, what instrument can you get and subscribe to? So obviously, firstly is the equity shares. These are plain vanilla equity shares. You have voting rights commensurate to that. The next and a very popular instrument is compulsorily convertible preference shares because A, it gives you preferential right to dividends and also allows you to convert your preference shares to equity down the line. If you want to earn a higher interest coupon, uh, then in that case you can subscribe to compulsory convertible debentures. These are the, I would say, the most common instruments which are allowed to be subscribed to and subscribed to by the investors. One fundamental point here is valuation. So when a foreign investor, let's say, invests into an Indian company, whether through subscription of shares or purchase of shares, it's not really a completely free hand. So, for example, if I'm a US company, I cannot buy a share for Indian company, which is valued, let's say, at $10 per share. I cannot buy it at $5 per share. I will have to at least pay $10 or more to the Indian company or Indian seller. However, when it comes to the foreign investor exiting the company and it becomes the seller, and the Indian party is buying shares from it, the the fair value becomes the floor price, and the US investor in this case has to cannot take more than $10. It can either receive $10 per share or less. It cannot take more. So fair value becomes a cap in this situation. Last couple of points, I think, is very important that no foreign exchange law is cast in stone. It has to be revitalized from time to time, and Indian system is no different. There have been a lot of sectoral and other policy liberalizations, including permitting share swap. Now, this is a critical change because a lot of times foreign investors wanted to put some cash and give some of their shares to do a M&A in India, and that was not allowed. And recently, this has been liberalized. Now you can use stock of a foreign company as a consideration to get shares of Indian company. And several sectors like space sector, telecom sector, these have been liberalized, keeping in mind the importance of the sector, the demand of foreign investors, and consultation with various businessmen and entrepreneurs. All of this augurs very well for time to come, and we will see perhaps more liberalization measures in recent and times and more time to come. I think next slide, please. So I think if I have to now conclude my presentation and uh, give a quick roundup of the key points why India is such a hotbed and why the climate of investment is conducive, we can go to the next slide perhaps. There you go. So I think firstly, India is a fast-growing economy. It's a well-known fact that it's perhaps arguably one of the fastest-growing economy, and that itself allows for more GDP, more investment opportunities, job opportunities, opportunities of all kinds, really, which emanate because of this kind of burgeoning economy. Specific sectors like IT, e-commerce, renewable energy have consistently seen double-digit growth rates. The government support is obviously critical, then that really continues through rationalization of various FDI policies, tax incentives, and initiatives like Make in India, Digital India, production link incentive schemes. They will continue to do well. Opportunities, as I mentioned, it's a fast market, growing infrastructure, a digital transformation, and across sectors you will find opportunities for this. I think another key point is stability. If the water is choppy, you cannot really enter the water, isn't it? So here there's a lot of stability because of the stable government we have, which leads to political and economic stability and a well-functioning democracy and a strong policy framework. Uh, the legal system again is critical, and India's legal system, as we have discussed, provides investor protection, fair dispute resolution, and enforcement of contracts. Uh, Demography is also a very important facet because India has a dynamic and youth population coupled with its vast talent pool makes it a hub for innovation and growth. Uh, so therefore, in conclusion, what I will say that India offers a unique blend of growth potential, government support, stability, and a business-friendly legal framework. By leveraging these advantages and navigating the regulatory landscape effectively, foreign investors can achieve long term success in one of the world's most promising markets. Thank you for your attention. I'm happy to now take any questions which you may have. Over to you, Nidhi. Thank you.
Thank you, Prasenjit, for that really interesting presentation. There are a few questions arising from that presentation that I think we would like to get your thoughts on, and I'm sure our audience will appreciate your perspective on some of these. So, the first question that I'd like to discuss is what, according to you, are the cultural differences between doing business in India compared with, say, doing business in the US?
Thank you, Devi. I think it's a very interesting question because when we conduct business in India, culture plays a very critical role as to how successful your business outcome will be. I think the first key difference I would be communication styles. Here in India, the communication styles are often very implicit, and you will have to read between the lines, and it may not be as direct, let's say, as in the American context, what we have seen. Uh, and that's one key factor. The second is the whole hierarchical system and the organizational structure, because in India, the decision making is very very top down. So you will have the promoter or let's say the person at the top will take all the shots, and he will be seldom be questioned or challenged by people reporting to him. And in that sense, the decision making is very centralized. Now that may be very different from US, where there is a flat organizational structure, there is empowerment, and it's not as hierarchical as in case of India. The third is, relationship wise, a lot of time is spent in Indian relationship building, whether it's, you have rapport building through meals, informal meetings. Not to suggest that US doesn't have that, but the degree of formality it is much more less in Indian context, and it's really a lot of relationship building which must be done if you wish to have a successful kind of partnership in India. Uh, the other thing is, time, punctuality, and all. More often than not, in India, if a meeting is to start at 9:15, it will start at 9:30. And I mean, one should not take offense with that, because that's kind of I would say a prevalent trend there. Unlike US, where 9:15 means 9:15, and therefore one must have patience and adaptability to kind of tackle that. Uh, the other thing is, the negotiations in India can be extremely protracted, and one may feel very, very exhausted. And one must have patience and persistence, because unlike US, where it's a goal-oriented negotiation, more often than not, in India, you will start off with that, but then it will veer into tangential things, and it may go out of hand. So you must have a lot of patience. Uh, One other thing is the communication. In India, when you often hear yes, it may not necessarily mean a yes. It may mean a okay. And so when you negotiate, uh, many times I've seen a US company in its notes capture something as agreed, but actually the Indian party said, "Look, I just said I acknowledge it." And so there's sometimes loosely phrases are thrown around, and once one must be mindful that these are not kind of cast in stone. And the last point I would say is the fact that India is a very diverse culture, and if you as a US client dealing with, let's say, a set of customers or vendors in southern part of India and northern part of India, they're very different in their style, communication, and culture, and therefore one must be mindful of that and carry them along if you wish to have a successful venture. Yes, that in a nutshell, Nidhi, some of the cultural differences which are critical to keep in mind if one has to have a successful investment future in India.
Oh, very interesting. Thank you for that. I think one of the other things that also kind of plays into the differences between deal making in India and deal making in the US is that India really doesn't have a common market standard for anything. So someone coming from the US, where they've done plenty deal making or run successful corporations there, if they're trying to set up an India presence or invest in India, every other lawyer or advisor would have their own perception of what market standard is, and that also adds layers and timing, like you said, to protracted negotiations in India. The next question, Prasadit, I think our audience would like to hear from you on is in the context of labor laws, how Indian labor laws specifically differ from that of, say, UK's, especially when you're handling business transfers and, say, restructuring exercises in India.
Right. I think that's a very interesting question because this is one question we oftentimes get asked in the UK context. And that do you have a corresponding law which allows automatic transfer of employees like tube law in UK? The answer is no, unfortunately no. So yes, the short answer is the labor laws differ radically in UK and India. Uh, Three four key points I would say is firstly, India has today multitude of labor laws both at the central level and state level, and while that is all set to be overhauled by the four labor codes, but that is yet to come into place, and that will simplify things. Because as it stands today, if you are doing business in India, you will have to have a good hang of multiple central and state labor laws, which is far more in number than in UK. I think the second key aspect is the transfer of employees part because that's the essence of the question. And in India, if you have to transfer employees from entity X to entity Y, you will have to kind of take their consent in order to transfer them. And if it's a blue collar employee, you will have to comply with the requirements of Industrial Disputes Act and offer them no less favorable terms than they currently enjoy today, failing which there will be, I mean, there could be disputes, retrenchment compensation, etc., which is there. Uh, so that's point one. The other key point is in terms of if you are looking to lay off people, especially these are blue collar employees with a large workforce. You may well run into a lot of labor disputes, strikes, etc., and things can go very much out of control. And this is connected with the fact that many large companies with large workforce have a very strong union. Now, while having trade unions is not uncommon even in UK, in India, the unions tend to be extremely influenced and connected with political parties, the regional political parties. And therefore, when you deal with such a workforce where you're looking to, let's say, do a reorganization, and as part of that, you have to get rid of people, retrench people, uh, that's obviously a very sensitive topic, and you have to navigate that extremely carefully because in the past we have seen the trade unions completely grinding the entire company to a standstill because the companies were extremely lackadaisical in their approach and how they dealt with the employees and unions they were looking to deal with. So it's very critical that how you tackle the trade unions with the political connection and needs to have an extremely expert kind of a handling requirement there. The other, I would say, difference between UK and Indian employment related aspect is the type of contracts we tend to have with blue collar employees. They're very sketchy, short form, rickety in nature, and not very well drafted. Unlike UK contracts, which obviously tend to be more evolved and better fleshed out. That's the other key aspects regarding this. Lastly, I would say the disputes. Indian labor courts tends to be extremely labor friendly, pro labor, and if you get into a dispute situation with a labor, the odds are you will come out second best. So therefore, it's very important that you handle the labor disputes in a very deft and tactful manner because not only it will dent your profitability and business if there's a stroke, like out, and dispute, but it actually will also dent your confidence and reputation. So very important to keep these local idiosyncrasies in mind when we deal with Indian labor laws. Over to you, Nidhi.
Thank you for that very detailed response. I'm sure the audience appreciates the key nuances that you've highlighted. I guess the last question, I'm just conscious of time, is what are the key areas that are regulated under India's antitrust laws that you think a foreign investor investing in India should be mindful of?
Right. I think, see, again, a very important law, and I think I briefly touched upon it, and I'm sure in future my other colleagues will, talk about it in more detail. But uh, India has, a competition law which is evolving. The principal legislation is 2002 Competition Act, and is enforced by the Competition Commission of India. Now, like most evolved, countries and advanced jurisdiction, the competition law here also seeks to achieve the principal objectives, which is to really uh, enhance competition and therefore thwart and prevent anti-competitive arrangements. So, for instance, there will be any agreement which is kind of a cartel, trying to fix prices or indulging in big bidding or limiting production or share market, etc. It will be obviously falling foul. Any kind of resale price mechanisms which sets minimum of fixed resale sales price of products, etc., can also land in trouble. Any exclusive supply or distribution agreement which thereby restricts the ability of other suppliers to enter the Indian market will also land in trouble and scrutiny of the competition authorities. Insofar as foreign investors who are doing, kind of investment into India, you must do a proper diligence and have robust compliance programs in place so that when you do invest into India, you don't fall foul of this kind of, breaches. The other obvious one is abuse of dominant position. That is obviously something the Competition Act in India governs. And if a dominant player kind of conducts itself in a, let's say, a manner where it is pricing its products excessively at exorbitant prices, or indulging in predatory pricing where you sell your products or services below cost to eliminate competition, or limiting its product to supply, they were restricting the availability of goods or service. All of this will be, scrutinized and penalized if found falling foul of Competition Act. Uh, and as a foreign investor, you must formulate your market strategy to enter accordingly. Turning to M&As, of course, if there are thresholds which are laid out by the CCI, and if the combined turnover, market share, and potential impact of competition or at least to control of the foreign party in these specific sectors exceeding thresholds which are stipulated, you will need prior approval of Competition Commission of India, which is a mandatory filing in that case. Equally, if the deal value, the asset or turnover tests are lower than specified thresholds, there is a de minimis exemption, and therefore, for those M&A transactions, you don't have to seek prior approval of the CCI. But should you need approval, the approval is in two forms: Form 1, Form 2. Form 1 is the more simplistic approval, and Form 2 takes a bit more longer, where market share, etc., gets involved, and a detailed economic analysis may be required. Uh, the other key point is penalties and enforcement, and fines up to 10% of the average turnover for last three preceding years can be imposed, for example, for cartels and anti-competitive arrangements. Now, what this means is that this is not something to be trivialized with, and there have been several cases of companies receiving rap on their knuckles, and severe penalties are being imposed by Indian authorities. And therefore, one would be well advised to get proper guidance and specific advised on these matters. The last point I would say is that all this is fine, and once you do set up a shop in India, this law is evolving. But the Competition Commission is emulating a lot of the global practices and implementing them. So keep a track of them through your local advisors specializing in competition law. Keep on modifying your policies, and also keep a track of the policies you have in place on paper, and make sure there is training programs done to kind of educate your vendors, customers, employees, so they don't indulge inadvertently in breach of anti-competition law. So with that, Neri, I will hand it back to you. Thank you.
Thank you for that, Prasenjit. With that, I would like to conclude the Q&A session. Can we move to the next slide, please? Yeah, I would like to thank our presenter for sharing his expertise and experience with us today. You were simply outstanding. Thank you so much. Also, thanks to you, our audience, for your attention and your questions. I hope you found the webinar to be a worthwhile investment of your time. We surely enjoyed bringing it to you. After the webinar, we will be sending to you a copy of today's presentation materials, summary notes, and a link to the webinar recording. You will also separately receive a request for your feedback on the webinar. Please take the time to send us your feedback. Comments, criticism, and even your compliments are welcome. The form will take less than 1 minute of your time to complete. If you are interested in in-house training or any other matters arising from this webinar, please do not hesitate to contact us. Our contact information is on the contact slide here. Thank you for your attendance today, and we look forward to being with you again at Investing in India.
Thank you, everyone.